Thank you. Great. Okay, I'm Melida Hudson, president of ASIL, and on behalf of the Society, I welcome you to this lecture by Layla Sadat, this year's awardee of our Goler T. Butcher Medal. The Goler T. Butcher Medal has been awarded by ASIL since 1997 to a distinguished person of American or other nationality for outstanding contributions to the development or effective realization of international human rights. It is named for Goler Teal Butcher, a prominent African-American scholar and professor of international law at Howard University School of Law, who served as Assistant Administrator for Africa at the U.S. Agency for International Development in the Carter administration and was a leading advocate for ending global hunger. So I am proud to introduce this year's eminent awardee, Layla Sadat, who will be formally presented with the medal this evening at the Assembly. Layla Sadat is the James Carr Professor of International Criminal Law at Washington University and was a visiting professor at Yale Law School from 2021 to 2024. She served as special advisor on crimes against humanity to the ICC prosecutor from 2013 to 2023 and is on the register list of experts for the Moscow mechanism of the OSCE. A devoted teacher and prolific scholar, she is recognized for her expertise in international law, human rights, and international criminal law, having published over 180 articles and books in leading journals, academic presses, and media outlets throughout the world. Sadat is the first woman to receive the Alexis de Tocqueville Distinguished Fulbright Chair and has received many awards for her work, including an honorary doctorate from Northwestern University, the Arthur Holly Compton Faculty Achievement Award from Washington University, the Klatsky Humanitarian Award from Case Western Reserve School of Law, and the Charles M. English Award from the American Bar Association Criminal Justice Section. In 2008, she launched the Crimes Against Humanity Initiative to write the world's first global treaty on crimes against humanity and continues to spearhead its negotiation and adoption at the United Nations. The title of Ms. Sadat's remarks today is The Long Arc of Justice, Forging a Convention for Crimes Against Humanity. Welcome, and please, Ms. Sadat, welcome to this committee.
Thank you so much, everybody. It's very exciting to be here and a little overwhelming, I have to say. It's an incredible opportunity to share some thoughts and reflections on the work that I've been doing about crimes against humanity and with respect to crimes against humanity. I'm really overcome by the honor bestowed upon me and accept it quite humbly, knowing that I literally stand in the shoes of giants. And actually, I literally stand in the shoes of giants because looking at my predecessors, I think I am the shortest person to have ever received the award, but I'm standing at my full height. Thank you so much to the Society, of which I've been a proud member for many, many years. And thank you to my university for its support, to the friends and colleagues, many of you are here now, with whom I have joined forces to walk this path for many years, as well as to the teams of students, some of whom are here now, who have helped me write, document, calculate, create, and suffer through a lot of this work. I'd also like to thank my family, obviously my husband and children who have endured long absences while I've been doing this work, but also my parents who taught me the beauty and promise of the United States of America and the value of working hard, fleeing religious violence on my mother's side and political violence on my father's. It's hard not to recognize at this particular moment that we stand on the cusp of a dark time, pouring into the abyss and trying to pull ourselves back from it. Human rights and human rights lawyers will be more important than ever in the days and years to come. And at this splendid and wonderful annual meeting, we have the opportunity to come together in solidarity, in community, and to help us weather and forge a path forward through these times. So turning now to the subject of my lecture, I'm going to frame today's conversation about crimes against humanity by reaching into a dark past. And in a way, it's particularly appropriate to start here, although that wasn't initially my idea when I thought about this lecture and some others. I'm going to reach into that past to better understand the central importance of how law and lawyers, with sometimes maddening technicality and exhausting rigor, can nonetheless make a difference to human beings on the ground and to human society in the larger sense. You are undoubtedly familiar with the transatlantic slave trade that took nearly 13 million African people from their homes between 1501 and 1867. They were kidnapped, forced onto European and American ships, and crossed the Atlantic in appalling conditions to find themselves enslaved, abused, and separated from their homes, families, ancestors, and cultures. This not only fractured and devastated the African continent for centuries, but turned the Americas into a place where race and color created a caste system defined by inequality and abuse. Slavery and the slave trade were crimes against humanity, crimes that by their cruelty and savagery traumatized not only the victim population, but forever changed for the worse and degraded the perpetrators, as Alexandre de Tocqueville observed during his travels throughout America. To stop the slave trade, like stopping slavery itself, seemed impossibly difficult. Doing so required moral courage, sometimes physical bravery. It also required physical, legal tools, international cooperation, and domestic and transnational enforcement. And that is where the current story begins. For reasons I'll make clear later, it's useful to start our examination of the slave trade as a crime against humanity with the voyage of the Antelope, which on August 24, 1819, sailed from Havana, Cuba, under a Spanish flag to acquire 350 slaves from West Africa. The saga of this vessel and the fate of its captives tells us much about the journey to transform morality and natural rights into international law. The Antelope was ultimately taken and boarded as it lay anchored in Cabinda Bay off the coast of modern-day Angola, and eventually made its way back across the Atlantic with approximately 331 enslaved persons in the hold. Many died along the way, and many more would perish after their arrival due to the horrific conditions that they were held in. Because the slave trade was by then illegal in most parts, the Antelope could not easily profit from her cargo, but finally made her way to the coast of Spanish Florida and then navigated up towards Georgia, where slavery was legal, but not the slave trade. It was captured by a U.S. revenue cutter and brought ashore in Savannah. The fate of the by then only 258 survivors, whose average age was 14, and more than 40% of whom were between 5 and 10 years old, was unclear. The captives had been taken by Spanish, Portuguese, and American vessels, and claimants stepped forward arguing that even if the slave trade was illegal under U.S. law, the law nonetheless required the courts to respect the ownership rights of the enslavers. The lower court upheld the claims of Spain and Portugal, but not the Americans. The U.S. government, believe it or not, took the case up to the Supreme Court on behalf of the captives. It was argued by the Supreme Court by two very famous Americans, Francis Scott Key, who you might know for the Star-Spangled Banner, and Attorney General William Wirt. They relied upon a line of British and American cases, including La Jeune Eugénie, decided in 1822 by Justice Story, who was riding circuit at the time, that had found that the slave trade was contrary to the principles of justice and humanity, prohibited by universal law, and violated natural law and the law of nations. And here you can see depictions not as gruesome as the actual thing would have been in what the slave trade looked like. Key and Wirt contended at a British court had found in Somerset's case, decided 50 years earlier, that because U.S. law prohibited the slave trade, under our law, they were not slaves but free men. And under this theory, the captives were free the minute they set foot on U.S. shores. Unfortunately, a closely divided Supreme Court disagreed in an opinion penned by Chief Justice Marshall, who found that although the African slave trade was contrary to the law of nations, it was not prohibited by positive law because it wasn't specifically criminalized or made unlawful by treaties. Justice Marshall rejected Portugal's claims on the facts, but he accepted Spain's, as the Antelope had set out lawfully as a Spanish slave vessel at the outset. That said, in what might be seen as a careful compromise, he did suggest that many of the captives did have to be returned. 120 were saved and returned to Africa, but unfortunately not to their homelands, but to Liberia, where they faced great hardship. Those not returned spent their lives basically in bondage in the United States, their stories lost along with their dignity and freedom. The story of the Antelope is less well known than the Amistad many years later that was memorialized by the gripping film by Steven Spielberg. And the Amistad ultimately set aside the Antelope's endorsement of the slave trade. But the Antelope's reasoning persisted and shaped the infamous Dred Scott case in 1857, and also that would shape what would become a civil war in the United States that killed an estimated 620 to 850,000 souls, more people than died in World War I and World War II together. An example of crimes against humanity in peacetime that led to war. 200 years after the decision in the Antelope, we see the same tensions we're experiencing today in the face of atrocity crimes. A court cognizant of geopolitics that even in the face of an 1819 U.S. law that rendered the slave trade illegal and likened the slave trader to a pirate over whom universal jurisdiction could be exercised in peacetime and wartime, nonetheless found that because there were exceptions existing to the prohibition of the slave trade, it was not truly universal and therefore did not form part of the law of nations, an argument that still finds some currency today, although the current slave treaties finally put that argument legally and juridically to rest. But the Antelope and the continued horror of slavery in the United States for some decades was not the entire story. These crimes against humanity, as they were widely referred to during the 19th century, were eventually outlawed everywhere, starting with treaties entered into by the British with the Netherlands, Spain, and Portugal. And these instruments not only prohibited the slave trade, but included mutual rights of search and seizure between the contracting parties outside the contact of war, or what we would now call interstate cooperation and mutual legal assistance backed by enforcement jurisdiction. And they even provided for trials in mixed commissions by treaty courts, including those set up in Sierra Leone, Havana, Rio de Janeiro, and Suriname, which we would now call international and national justice. As Professor Jenny Martinez has noted, slavery and the slave trade were endemic in 1800 and had been eliminated by 1900 intentionally by people who had come to believe it was morally wrong. It was eradicated in part by military force, but also by coordinated international legal action, including the establishment of international courts established by treaty. So what does this legal history mean for the development of a new treaty on crimes against humanity? It tells us that treaties matter. They make clear the obligations of states. They provide for interstate cooperation. They include jurisdiction for courts to adjudicate cases. Without them, we're at the whims of judges who may sometimes, like Justice Story in La Jeune Eugénie, reason in one direction to declare an atrocity a crime, but in others, like Chief Justice Marshall in the Antelope, arrive at the opposite conclusion. Fast forward now, you knew I was getting there, to the modern era. What are these crimes against humanity? Their legal elements need little introduction to this learned audience. The term is generally attributed in our time to a meeting between Hersch Lauterpacht and Justice Robert Jackson, as beautifully chronicled in Philippe Sand's extraordinary book, East-West Street. However, as I've already alluded to, the concept did have a long prior history as a description of slavery and the slave trade, King Leopold's atrocities in the Congo, and the massacres of the Armenians in the early 20th century. It was enshrined in the Martens Clause of the 1899 and 1907 Hague Treaties, which provided, and you can see it up there, that until a more complete code of the laws of war has been issued, the parties remain and the inhabitants and the belligerents remain under, quote, the protection and the rule of the principles of the law of nations as they result from the usages established amongst civilized people, from the laws of humanity and the dictates of the public conscience. And thus were morality, natural law, and the law of nations unified in this important preambular paragraph. Crimes against humanity later materialize in Article 6C of the Nuremberg Charter, and they get incorporated into a handful of national systems, included in the statutes of the ad hoc tribunals, and codified as Article 7. This is the Nuremberg Charter here, and I'm going to fast forward to Article 7 of the Rome Statute. You can see that the original iteration at Nuremberg was much shorter than the complex definition that we have today. They're mass crimes. They take many forms: a state policy of torture or disappearances, a campaign of rape or other forms of sexual or reproductive violence, arbitrary arrest and detention, typically accompanied by inhumane conditions, mass expulsions or deportations, often referred to as ethnic cleansing, or mass murder of individuals by a government or non-state actors in war or in peace. As Antonio Cassese observed, they're characterized either by their seriousness or their savagery, or by their magnitude, or by the fact that they were part of a system designed to spread terror, or that they were a link in a deliberately pursued policy against certain groups. Over time, 4 key features emerged from the jurisprudence of the ad hoc tribunals and the ICC, and they were incorporated. Crimes against humanity protect all civilians, including a state's own nationals, from widespread or systematic attacks on their human rights that rise to a certain level of seriousness. Second, unlike the crime of genocide, although the crime of persecution addresses attacks undertaken on a discriminatory basis, persecution or discrimination is not an element of a crime against humanity, although it is often present. Third, the perpetrators of crimes against humanity may be state or non-state actors, including but not limited to organized armed groups. And fourth, unlike war crimes, crimes against humanity can be committed during armed conflict or in peacetime. And finally, the Rome Statute added an additional element, was the policy element, that the crime has to be committed in furtherance of a state or organizational policy. This Rome Statute definition, which will undoubtedly become the centerpiece of the new treaty, expanded, as I said, on Article 6C. So why is the prosecution of these crimes so important? And here you can see some of the other elements. I call this an atrocity cascade, which is where human rights abuses deteriorate to the point of becoming criminal, and if not staunched, descend further even into war or into genocide. And I have a visual depiction of this here. Prosecutions or other forms of legal advocacy based on crimes against humanity can start prior to the onset of war or the commission of genocide, rendering crimes against humanity charges a potential tool for mass atrocity prevention. Human rights violations occur in every country in the world, and most national systems have mechanisms to address them. Typically, they're sporadic, so addressing them is within a country's domestic jurisdiction. There are also treaties and institutional mechanisms that address human rights issues at the international level, but sometimes both the national and the international fail, and they overcome the ability of the national system to address them and leave the international system to condemn, but without concrete enforcement. If they reach a certain threshold of seriousness, they may become crimes against humanity. There's thus a frontier between human rights violation and criminality in peacetime, which you can really see, where combating crimes against humanity is really important, and it's why a new international treaty is so critical as well. This peacetime importance of crimes against humanity is particularly evident in the work of the International Criminal Court, as I discovered during my 10 years of being there and my studies even since. Crimes against humanity have been alleged in all the situations referred to the court and most of the cases. In situations involving armed conflict, crimes against humanity will often track the war crimes charges or are added to target persecution or sexual violence or fill gaps in the laws of war. In many situations, however, like Venezuela and the Philippines, as recently demonstrated by the arrest warrant executed against former President Duterte, the crimes against humanity charges are the only basis upon which the ICC can exercise jurisdiction, given the absence of an armed conflict and the implausibility of alleging genocide. Thus, crimes against humanity can serve as an important tool of genocide prevention, applicable before atrocity levels spin completely out of control in a situation that's degrading into conflict or overwhelming levels of atrocity crime. Syria is a good example. In a study I published in 2013 in the American Journal of International Law, of the 8 situations before the ICC at the time, 30% of those cases were crimes against humanity cases only, in contrast to the ICTY and ICTR, where it was 1.2%, just to show you how different it is now with a court that can act in real time. But given that we have the ICC with 125 states parties, we still have to answer the question, which I have for many years, why do we need a new treaty? Well, first of all, our experience with the ICC demonstrates that it takes very few cases. This was a prediction in 2008. It's a clear reality today. We're also seeing a resurgence and a recrudescence of these crimes around the world. There's no duty in the ICC statute for states to criminalize the offenses, although there's an encouragement to do so, and there's no obligation of prevention in the ICC. And finally, an ounce of prevention worth a pound of cure. This requires building up state capacity and imposing an enforceable duty of prevention, like the one in the Genocide Convention that was really taken by the International Court of Justice and given life in Bosnia versus Serbia. And finally, in order to effectively investigate, prosecute, and deter these crimes, states need interstate cooperation. They need to have mutual legal assistance as a possibility. The ICC is a vertical mechanism. A new treaty would be a horizontal one instead. Thus, you can see there are many gaps: a legal gap, an impunity gap, a state responsibility gap, a lack of state cooperation, and definitional uncertainty. So in 2007 and 2008, a few years ago, I launched something called the Crimes Against Humanity Initiative, directed by an international steering committee of luminaries that helped to shape and direct the project. And you can see this was the picture we took, and I'm going to come back to the reason why this room is important. Through an iterative process, convening meetings in St. Louis, in The Hague, in Washington, D.C., and reaching out globally, we brought together more than 250 experts to draft what we called an academic offering to the world's first international treaty for the prevention and punishment of crimes against humanity. That treaty and the academic work that shaped it is now published. It took Article 7 of the Rome Statute as the core, and it rested on 4 pillars identified with basically the gaps that I already meant. Our model treaty contains 7 articles, 6 annexes, and its own Martin's Clause, adopted Article 7 of the Rome Statute, provided horizontal enforcement, and built upon 4 pillars: the normative, the preventive, the punishment, and the capacity building. So I now turn to the International Law Commission, and I should add one little note, which is that our annexes that had the interstate cooperation provision were actually taken and became the subject of a different initiative, the Hague-Ljubljana Treaty for Mutual Legal Assistance, which is not yet in force, but has been negotiated. So now we move to Geneva. we leave St. Louis and we go to the International Law Commission. And the story, and I want to emphasize that this is a story about people and their work. In 2010, we held our last meeting at the Brookings Institution, and Professor Sean Murphy attended our meeting. And Professor Sean Murphy was then elected to the UN International Law Commission and decided to make a treaty on crimes against humanity a centerpiece both of his election campaign and his work, of course, at the International Law Commission. In 2014, we hosted a conference at another famous building, the Villa Moignet in Geneva, to support the work of the commission. And for several years, Professor Murphy would write a report, submit it to the commission, present draft articles, the commission would work on it. It was an iterative process, basically, of ping-ponging back and forth between the commission, civil society, states in the Sixth Committee, back to the commission. And after several years, you can see from the slide that in 2017, there was a first reading, governments commented, and then in 2019, we had a second reading. And the second reading are the Commission's draft articles for the prevention and punishment of crimes against humanity, and they took as the centerpiece Article 7 of the Rome Statute, basically with a few modifications that we can talk about. And they had a series of articles, 15 in toto, and an annex, sort of like our project, but shorter. General obligations, obligations of prevention, non-refoulement, et cetera. I can go back through these, but I don't want to spend too much time. And they made a recommendation. And I love this recommendation. And I remember my husband saying, was it really the 3,499th meeting, right? And it really was, that the commission recommended the elaboration of a convention by the General Assembly or by an international conference of plenipotentiaries. Well, as the project director, I'm super excited, right? This is great. We're moving to New York next, and all's gonna go well. Oops. So it didn't quite happen the way we thought it might happen, and I see some wonderful legal advisors here. And we moved to New York to sit in the basement of the General Assembly building, and eventually it went well, but it didn't go so well initially. So what happened in New York? It took 6 years for the commission's draft of 2019 to be sent to a diplomatic conference, basically, and I'll talk a little bit about that. So from 2019 to 2021, we had technical rollovers. The difficulty is that the Sixth Committee of the General Assembly, the legal committee, works on the basis of consensus. So if states say, we need more time to study it, we're not really sure if we're ready, or we just don't like this idea, a handful of states can block progress. And for 3 years, that's what happened. 2020 was particularly difficult because of the pandemic. 2020 and 2021, civil society couldn't get in the building, which I think also made a difference. But it was very hard. There was a huge amount of enthusiasm in 2019, and it was very extraordinary to see how the core group of states supporting this sort of stuck together over the next 3 years to say, how are we going to get this done? How are we going to overcome this? Well, in 2022, determined to avoid a repeat of 2021, a cross-regional group of 8 states, Colombia, Costa Rica, Gambia, Mexico, Korea, UK, and the United States, adopted what's called a zero draft resolution shortly after the start of the Sixth Committee session, but before the date scheduled to take up crimes against humanity, which would have required a vote unless states could work together to find a consensus path forward, which they did. So I'm not going to go into all the details of what happened, but basically there were long, extensive negotiations, and eventually, at the end, there was, in fact, a resolution that was adopted, 77/249, which provided a 2-year period during which the commission would, the Sixth Committee would meet in interactive sessions in order to exchange substantive views. There's lots of kind of loose lawyerly language in this resolution. The bad news was it stayed in the Sixth Committee, which had the consensus problem. The good news was through the really eloquent use of the mini debate, through very successful negotiations, through the perseverance of our friends from Mexico, the Gambia, Canada, Thank you. The United States, so many states, Sierra Leone, Portugal, the European Union, Palestine, really so many states came together to work assiduously over the next 2 years. And you can see, because one of the things my students helped me do is every year since 2013, and I haven't showed you all the slides, I did at the Nuremberg Academy and I saw a couple people sleeping. So I shortened this presentation a little bit. But you can see in 2022, there's pretty significant support. Okay, we've been tracking the number of positive states, the number of negative states, the number of, we're not really sure what we're supposed to do with these states. 77/249 was adopted with 86 co-sponsors and a total of 100 states supporting the draft text in some measure. And for the first time, it really did allow for a process to move forward. Now, in 2023, we had the resumed session, very, very positive results. Introduction of substance into the conversation, I think, really changed the dynamic. Civil society was able to be in the building in 22 and 23. I see some of my civil society friends, too, working hard. There were political risks, and current conflicts had happened, right? The war in Ukraine, I think, was changing the dynamic. We'll see in 23, the war in Gaza changes the dynamic as well. In 2023, we see increased support from states in the Sixth Committee, moving cautiously towards the hope that after the 2-year period is up and the Sixth Committee is going to take a decision, we're going to be able to move forward. And so just as Mexico and the Gambia had, and I say this with deference to Pablo Arrocha, who lets me use this, flipped the tortilla on this process by depositing the resolution early, they did the same thing in 2024. And in 2024, there was a very strong resolution that was a 0 draft that was submitted. I have to say I cried when I saw the words, decides to convene the United Nations Conference of Plenipotentiaries. Remember when I started this project, not the 19th century, okay, I'm not that old, but still, it was a few years ago, and we had the possibility of moving forward. Of course, the fact that they had to move forward by consensus was going to make the conversations and the negotiations really, really challenging. And challenging they were. I'm not going to repeat some of the challenges. I see some of the beleaguered delegates here in the room, but the negotiations were challenging. We had an enormous number of states speaking out, 145 states and entities this time, with 125 states expressing positive views, 7 remaining neutral, and 13 expressing negative views. You can see that from the slide. Several states, which was very encouraging, that had previously expressed concerns, including Egypt and Nigeria, turned around and were positive in this session. Sierra Leone, taking the lead, delivered a cross-regional statement on behalf of 77 states. There were still states saying we need more time, we need more study, but most appeared to agree, and I'm just using Brazil as one example, that there's never going to be an ideal moment and that time is of the essence when it comes to the preservation of human life. And I'm not going to go through all of the different regional groups and states that spoke. I think what was memorable about the Sixth Committee session in the fall, that is occasionally the voices of the victims would break through. And they would break through through the state representatives that raised them. South Africa noted its own painful and wrenching history with the crime of apartheid. The current ambassador for Afghanistan, not representing the Taliban, referenced the scourge of gender apartheid. Haiti and Sierra Leone spoke to the horrors, continuing legacy of modern-day iterations of slavery and the slave trade. Bangladesh, Israel, Myanmar, and the state of Palestine spoke personally as well, referring to painful experiences in the past and the present. Poland condemned acts on children. Nigeria expressed strong support, but also said we need to address crimes of concern to African states, including colonialism, and emphasized the need for reparations. The few states maintaining their opposition included the Russian Federation and China. So on November 22nd, 2024, After an exhausting and dramatic day of negotiations conducted in person and by WhatsApp chat, the Sixth Committee, and those of you who are in the room know what I'm talking about, adopted a draft resolution to sustained applause, co-sponsored by 99 states by consensus. And you can see how consensus and support continue to grow by looking at my slide. And as I said, I think Maddie George is here somewhere in the room. Maddie was one of the first people that had to work on these, there she is, had to work on these charts. Many, many people have had to work on these charts over the years. And you can see that the dip is the pandemic, which was an outlier. So this resolution was then adopted by the General Assembly as Resolution 79/122. It sets out a framework to move forward over the next 4 years with a working group of the conference. There was a stronger resolution that was on the table before the negotiations. This is a visual depiction, and again, thanks to one of my students, because I couldn't make this slide. You can see what the roadmap is, literally looking forward. The time period was lengthened. The original draft would have had this treaty negotiated in 2026. We now have a preparatory committee meeting in 2 sessions, time for government proposals, and then 2 potentially 3-week sessions in 28, 29. But it's on the UN website and it's totally official. So the struggle to do this and win state support for a new treaty on crimes against humanity against the backdrop on a world on fire with their commission has been long, with many players and many partners. Some have been states that, like Great Britain's quest to abolish the slave trade in the 18th and 19th centuries, have been willing to take the lead in galvanizing world opinion. Others have been legal experts, UN officials, members of civil society, including organizations of survivors and victims. It's taken sustained effort, procedural innovation, diplomatic acumen, and hard work to get this project this far, an effort that has truly spanned the globe and has been led by the Global South and largely, but not entirely, by women. Now comes the real push for the next 5 years when at last the substance of the new treaty can take shape. So the ILC's draft articles provide an excellent starting point for negotiations, but there's still some questions. The chair's summary report from the 2 April resumed sessions includes many comments by states relating to the text, as do the comments already submitted by governments, which have another opportunity to submit proposals before April 30th, 2026. Questions have been raised about the absence of the Martens Clause, the unusual drafting of the definition of persecution, the possibility of adding incitement, the prevention elements, including a definition of victims, more fair trial rights, and you can see, should there be a treaty monitoring body? And since the Commission doesn't do final clauses, what is the treaty going to say about things like reservations, ICJ compromissory clause? Concern about gender competency and children's rights has also been raised. States will have their opportunity to submit formal proposals, but now is the time for study and preparation. Of some concern, to me at least, is the deleted provision ensuring robust civil society participation, which was eliminated from the zero draft as negotiations intensified last fall. I really saw during the 6 years that the treaty languished in the Sixth Committee that CSO participation was important to helping the forward momentum. When we could get in the room, the dynamics really changed. Resolution 79/122 does permit ECOSOC accredited organizations to attend the preparatory committee, presumably the working group, and the diplomatic conference. But other civil society members may not be able to get in. More than 650 experts around the world weighed in this fall with a declaration supporting the treaty, and Avaaz generated an online petition that got over 500,000 signatures in 3 weeks. So robust civil society participation and strong advocacy is going to be necessary. You know, at the end of the day, the real beneficiaries, and we're going to come back to where we started, will be those who receive justice or who do not become the victims of crimes against humanity to begin with. We don't know how many people will benefit, and we can't stop all crimes or punish all perpetrators. Returning, however, we know that the slave courts in Sierra Leone, heard more than 500 cases, and according to Professor Martinez's research, saved an estimated 65,000 enslaved person, plus another 90,000 who were never enslaved at all. Perhaps this is one of the reasons that Sierra Leone has been one of the champions of bringing this forward today. I heard a civil society participant say, when I was in The Hague doing a meeting in December at the ICC ASP, that this treaty is not just a piece of paper. It's really a promise to survivors. History tells us that its adoption will be a necessary but not a sufficient first step in preventing and punishing the commission of crimes against humanity. Without it, we're missing a critical legal tool, as the 19th century experience with the slave trade tells us. With it, we have at least a chance to save victims, survivors, and ourselves. As former Supreme Court Justice Robert Jackson argued nearly 80 years in a courtroom I had the honor to stand in about 2 weeks ago, civilization asks whether law is so laggard as to be utterly helpless to deal with crimes of this magnitude. It does not expect that you can make war impossible, but that you put the forces of international law on the side of peace. Even once the treaty's adopted, the hard work will need to continue. A ratification campaign, enforcement by states will be important. And I suspect the most difficult part of the journey probably lies ahead, not behind, particularly given the current geopolitical environment. Yet we take heart from the example of the U.S. experience with the horror of slavery, that although the arc of the moral universe is often painfully long, it does indeed bend towards justice, as the Reverend Dr. Martin Luther King reminded us in 1965. I can also hear Ben Forenz's voice in my head with his usual admonition, never give up, never give up, never give up. At this juncture, however, it seems appropriate to pause for a moment and be grateful for the adoption of this resolution to convene a UN diplomatic conference of plenipotentiaries on the prevention and punishment of crimes against humanity. And it's been supported by 192 out of 193 UN member states that adopted it by consensus. I've been really privileged to be a part of this journey, a small part of a long arc of history indeed, and encouraged by the support of so many along the way, as well as this award. And here I just have to show you the reason the room is important where it started is it was the site from which the call for the 1907 Hague Peace Conference came in 1904 when the World's Fair was held in St. Louis, Missouri. That's where we took our first slide, and I have to give a shout out to my students and everybody else, and that's where we just took a final slide, and I even have the t-shirt, look. And here you have sitting in the chairs the legal advisors of Mexico and the Gambia, who we invited to St. Louis with some others. Thank you so much for your kind attention. Thank you to the Society for the award and the support. And obviously, I'll be happy if there's time remaining to answer any questions. Thank you. No questions? It's like my classes. I see a question.
Well, thank you so much for this presentation and for all the work. I am Aisha Umana, a JSD candidate at Cornell University. Many people have been comparing this with the Genocide Convention because it's not this Rome Statute for a specific tribunal. And one of the teeth of the Genocide Convention is the obligation to implement it domestically, which also triggered a big diversification of protected groups of acts that constitute the crime of genocide. If this went through, hopefully, what do you expect is going to be the implementation of this convention domestically? And is there going to be a diversification or not? Or what do you expect it's going to be? Thank you.
Yeah, thank you. Do we take 2 or 3 questions or answer one at a time? Maybe another one? I'm going to write it down. Oh, I don't have a pen. Okay.
Hello. Thank you so much for the wonderful talk. Leon Castellanos from the Asser Institute in The Hague. Hi, Leila.
I can't see with the lights.
Congratulations.
Thank you.
I'm very interested in your experience as a scholar, spending time in these diplomatic spaces. What was it like to be a professor of international criminal law, negotiating sometimes, right, with really counterparts who had a really different life experience and expertise, namely diplomats in the basements of the UN. So what advice do you have for young aspiring scholars who also would like to follow perhaps in some of your footsteps in influencing these processes for decision makers and stakeholders? Thank you. How can we transfer those skills?
Yeah.
Thanks.
Any other questions? Somebody, yes, Allison or Tess? Or Allison and Tess, and then okay, diversification. Thank you, Michael, for the pen.
I'm Allison Dundies-Rentelm from USC, and congratulations and thank you for your brilliant lecture and all your incredible leadership in the field. I'm wondering about the issue of legal translation. There was an article about multilingual treaties and how they have to be provided within the UN system, and I wondered if you could comment on any challenges you might have faced with respect to that. Thank you.
Thanks.
Hi, Leila. Tess Graham with the Global Justice Center. And I wondered if you could speak to the role of, we know that the ILC is charged with the codification and progressive development of international law, and we know that these draft articles have been based very closely on the Rome Statute definitions of crimes against humanity. What do you think is the role and opportunity for the progressive development of the crimes against humanity definitions, and how can we make them fit for purpose for the 21st century?
Thank you so much. Wow, 4 great questions. So Article 6 of the International Law Commission's draft talks about domestic implementation. It has an obligation to adopt national legislation, just like any other criminal law convention, right? It's going to be a modern criminal law treaty, so it won't really look like the Genocide Convention, which is 1948. It's going to look more like the Torture Convention and forced disappearances, or maybe even draw a little bit, especially in mutual legal assistance, from the organized crime conventions, this kind of thing. So states do have an obligation to implement. States will vary when they implement because their national systems are going to need to be accommodated. This is going to be national law, domesticated international law. That said, I see the treaty as a floor, right? They can't go lower than the treaty and comply with their treaty obligation. So they couldn't unprotect certain groups that are protected by the persecution provisions of the treaty, for example. They couldn't delete certain crimes and still, in my view, really be fulfilling their obligation under the treaty. One of the things that I think will be important is if states decide to put back a treaty monitoring mechanism, which was in our project but is not in the ILC draft for a variety of reasons, I think that treaty body could provide some ability to comment upon, synthesize, act as a monitor, act as an interpreter for the convention itself, and that is the hope. But it's a great question. There will be some fragmentation for sure. It's just something we sort of have to live with. There's a weird little note in the ILC commentaries that talks about if states vary the treaty, they can't use the MLA provisions. I think that's actually not quite right. That kind of very positivistic interpretation is never used for the international law treaties. As you said, the Genocide Convention is often amended, right? They add political groups. Some states, Canada, I believe, has already changed the definition of persecution with respect, from the Rome Statute definition. So we are going to see diversity. And I think if we think of the treaty as a floor, then that's probably the best way to think about it. On transfer, so, Leon, I had the opportunity, and And when I was at Nuremberg, I dedicated my lecture to Sharif Bassiouni and to Ben Ferencz, two sort of giants in the field who really helped shape my thinking. And I sort of had the opportunity to follow Sharif around when I was in Rome. And those of you who knew Sharif knew he was the consummate international negotiator. And I just learned so much from him. There was never a problem. When somebody argued with you or debated something, you were just, okay, great, let's have a conversation, let's do that. So I had the opportunity really to watch the Sixth Committee for a long time in the PrepCom and be in the Rome conference, very young, you know, and that was a great lesson to me. I think I've learned so much from watching the tenacity and the skill of the diplomats in the Sixth Committee. I think sometimes our national politics could benefit from the kind of kindness with which they, you know, even when they have something strong to say, you know, it's sort of the classic focus on the problem, not on the person. Don't treat the person unkindly, focus on the issue that you're trying to negotiate. So I've really tried to take that my model. Multilingual treaties, oh my gosh, Allison, we had so many problems. We translated our treaty into English, French, and Spanish, no problem. We could use all the treaties, all the native speakers. I speak French and I can dabble in Spanish. We then got to Arabic, Russian, and Chinese, and we discovered that the United Nations treaty databases were kind of a mess. We had a formal Arabic translation. We paid a lot of money for it, and then Sharif read it and said, oh my God, this is like totally wrong. So once we got outside of Western languages, it became really difficult. If you look at our website, we also have German and Portuguese because those were donated to us. But I do think that translating is an issue. I think this is also why you see this way of speaking amongst diplomats, because you have to be really careful. What sounds funny in the United States might not be very funny to somebody who's French or German or Arabic speaking, right? So that kind of care and caution is important. And we did have translation issues, and I'm sure there are going to be translation issues today. So progressive development. Our treaty was an academic offering, and I still remember a debate amongst the steering committee members with a particular provision, and if you read our draft, you'll see that on immunities, we take Article 27 of the Rome Statute, paragraph 1 and 2, as our immunity provision for this treaty. Now, states don't like that. At least some states don't like that. And I still remember France calling us out in a very early stage saying, we don't need this Washington University, you know, model because of the immunities provision. But we were academics and we wanted to put out what we felt was the right treaty model at that time. The International Law Commission has to go back to states every year. It's going in dialogue with states, and so it can't go wildly out of touch. It has to stick to the law, of course. I watched the debates in Geneva, very thoughtful, very committed, but the commission itself is in dialogue with the General Assembly. Now, and civil society has its own demands. What I have seen is that at the beginning, our decision to take Article 7 as the centerpiece and the Commission's decision to copy that, states at the beginning really liked that. There were states that said, no, we have to copy-paste the Rome Statute so that the vertical and the horizontal was identical. And what we saw over time, especially during the two-year period after 77/249 was adopted from 22 to 24, is that you were getting states saying, you know, I think we could make some modest improvements here. In part, that was due to the civil society campaigns. I see patty sellers, slavery in the slave trade, gender apartheid, a lot of briefs coming in on some of the gender-related crimes, but also people coming in and talking about children. Nigeria is saying, what about colonial crimes, environmental crimes? I didn't really talk about that, but can there be a 12th crime against humanity so that this treaty is really for the future? Because once we codify, we know the codification stays. We see all the advantages. I told you about all the advantages of codification is they give you tools. but they also harden the law. And so it is important that the law be as progressive as states can stomach. And so we will need civil society, I think, in the building, and hopefully we'll get to a really good result. But I think there are some opportunities for expansion and development, and it may be that the long timeline helps us, not hurts us. I've had to learn to be very patient. Sometimes you just want to get it done, and you realize it's just going to take a while, and that's going to be a good thing at the end of the day. Thank you so much, everybody. I see the little clock is ticking. I really appreciate it. Thank you.